Grateful. In come back at 1 p.m. for the other motions. Yes, the review motion. Make announcement. Your feeling is going to be it's okay. You're going to lose.
questioned by the intransigence of our colleague lawyers for the petitioner. You will recall that on the last date of court, that is the 20th of January, the court made definite orders to be complied with by all lawyers in the case, lawyers for petitioner, lawyers for first respondent, and lawyers for second respondent. The petitioner was to have filed his witness statements by the 21st of January 2021. First and second respondents were to file their witness statements on the 22nd of January 2021, incorporated with their submissions on the preliminary objection to have the petition dismissed for disclosing no reasonable cause of action. As was to be expected, the petitioner flatly decided to disobey the orders of the court and was openly defiant even this morning. I must say that as practitioners of the Supreme Court and as lawyers who attend to court regularly, we need to exercise a little bit of restraint in the choice of our language. It's very important, because at all material times we are officers of the court. It's unfortunate the language used by my good friend Tony Lita this morning. It was a bit offensive to say that an application before the court has been predetermined. To say the very good friend, of course, and a very senior member of the bar. Well, the court did not take kindly to that. As it is now, the court has been gracious and very lenient to the petitioner, because they've been given another opportunity to rectify the wrong. The petitioner has been ordered to file his witness statements by close of day tomorrow, which is Wednesday. The petition has been adjourned to the 28th of January for hearing, which is Thursday. Now, I must say something. We are all legal practitioners. The Supreme Court is a very busy place. The Supreme Court is not a forum for organized, rehearsed, and choreographed theatricals or melodrama. It's a place for real, hard, and serious legal work. It's not for flurry of literature, long prose, and rather dull English, devoid of any legal merit. I want to advise my colleagues on the other side that if it ain't broken, don't attempt to fix it. We are ready for them on Thursday. Thank you.
The petitioners at every material time have said that they are remedies, and in the law, we found about four motions and applications. What's the process? What do you think this will move on before the next day?
No lawyer has an unfettered right to say that any application he or she files is within his remit. That is why we have the law lords. You don't come to court with the preconceived notion of what you think you have filed. The court at all material times is governed by rules, and the court applies its rules to the letter. They have no unfettered right to come to the court with the needless and unnecessary applications they are filing. You, in one breath, you don't want to obey the court. If you were in court, you should have listened to what the judges said. You are coming to court for a discretionary remedy. You have been ordered to file a witness statement. You claim you have filed stay of proceedings, so you disobey the orders of the court. Yet, you file an application as late as yesterday, and you want the court to entertain it. That is not what trained lawyers are taught to do. If you disobey the orders of the court, it comes with these consequences. The court has given them the last opportunity. Let us see what they will do.
You had made a point that you wanted a case to be brought to petition, and this development takes away some 2 or 3 days from the vote in terms of the deal that to the court. This should be a contest.
Do you want to blame it on us? The one who brought the petition is delaying the trial. What can we do as lawyers on the other side? They are screaming that justice is being sacrificed on the altar of expedition. By their conduct this morning, do you think they want this case to be heard rather hurriedly? Don't blame it on us. When they come, ask them questions. Don't blame this on us. When they come, they'll be here soon. You ask them questions. We are trying as much as we can to comply with the orders of the court and make sure that this petition is heard within the 42-day remit that has been set by CR 99.
From the submission of Mr. Chikasa following the decision of the court, one could sense some remorse that the court has misunderstood their intentions. Do you still think that this is part of some deliberate design to delay the case, or you think that genuinely they misunderstood what the operation of the action should have been?
Well, my guess will not be as good as yours. But all I can say, I cannot interpret Mr. Chajikate's demeanor in court this morning, whether he has showed remorse or not. All I can say is that he has obliged the court that they will comply with the orders of the court. We come to court on the 27th. Whatever they think they are doing is their baby, it's not mine. If they want this petition to be heard, it will be heard. But the court has warned them that CR 99 has its own rules, and that if you fail to obey the dictates of CR 99, your petition can and would be struck out. That should be instructive to them.
Thank you, Councillor.
Thank you
very much.
Thank you.
Men of the press, I am sure you are all witnesses to what happened this morning in court. The Supreme Court has given an order for the petitioner's witness statement to be filed by close of day tomorrow, and for us to resume hearing of the case on the 28th. But before I go into what has happened today and other matters, I want to record our disappointment with respect to the language used this morning by a senior member of the bar and former president of the Greater Accra Regional Bar, Mr. Frank Davis. The language that he employed this morning is unacceptable in describing the actions of petitioners' lawyers as theatricals, in describing us as persons who intend to be intransigent and disobedient to the orders of the court. I am sure that Mr. Frank Davis knows that all the applications that we have brought are within the framework of the law. You are journalists. Please do a bit of research. Read CR 99, and please tell us where in CR 99 it is said that you cannot bring an application for stay or proceedings. Tell us where in CR 99 it is said that you cannot bring an application for interrogatories. And tell us where in CR 99 it is stated that as a petitioner you cannot bring any interlocutory application before the court. These are all mechanisms that legal practitioners employ, and we have employed them in a way that is not abusive of our rights within the framework of the Supreme Court rules. And so for him to employ that language is most unacceptable, and we take exception to what he said this morning. Ladies and gentlemen, there is a fetish that is being made of 42 days stipulated by law for this trial. Again, I want to refer you to CI 99, which is the amendment to the Supreme Court rules CI 16. Go and look at Schedule 2 to CI 99. The schedule is very clear that the trial is supposed to take place from January to March. Now just do a bit of computation. January has 31 days. If February is not in a leap year, it has 28 days. And then March has 31 days. That's 90 days for you. Was the lawmaker wrong in stipulating this period for a trial? The view we have taken of this matter is simple. That the trial is supposed, the 42 days is the number of days, working days, that the court is supposed to use in discharging the petition. It is not to be computed on a day-by-day basis. I also wish to make it abundantly clear that this is far from being a frivolous and vexatious petition that His Excellency John Dramani Mahama has filed. The impression being created by the MPP, the ruling MPP, is that we came to court with a frivolous and empty petition, and we are just seeking to engage in theatricals so that the petition will not be heard. His Excellency John Dramani Mahama is far from being such a person. If you look at the petition, it has two purposes. The first one is to hold the chairperson of the Electoral Commission, Jane Adukwe-Mensah, accountable for a violation of the Constitution. Now, if you have practiced journalism in this country for a period sufficient enough to know that we have never had a situation where the chairperson makes a declaration based upon one figure, issues an instrument validating the declaration based upon the figure that she has used in making the declaration, and then subsequently revises that figure. Repeatedly revising the figure. Now that is unconstitutional conduct, and we want her to be held accountable for that. We are saying that that conduct that she engaged in is unconstitutional. It's not supported by any provision of the Constitution. And again, as journalists, you should be asking her, when she did the revision, were there agents of the political parties there? That is a critical question that you should be asking her. The second purpose of the petition is with respect to the mathematics of Article 63, Clause 4 of the Constitution. It requires that for a person to be validly declared president of this republic, the person must have obtained more than 50% of the votes. Our petition is very clear that His Excellency Nana Addo Dankwa Akufo-Addo, when he was declared president-elect by the chairperson of the Electoral Commission, had not obtained more than 50% of the vote. That is the mathematics of Article 69. And if this is not an important issue, I don't know what it is. And therefore, as journalists, when we file our witness statement, read it carefully, and you will see that this is not an empty petition. They are preempting Ghanaians to think that we are joking in court, but we are not joking in court.
At the start of the proceedings, we realized that your colleague, Mr. Salita, was explaining to the court why you didn't file the witness statement. If you could clarify that point.
Yes. We did not file the witness statement because we had filed an application for stay of proceedings. Now, for a layman, that is an application which is brought before the court to stay its hand with respect to everything in relation to the proceedings, pending the determination of a matter that an applicant has put before the court. And you recall that we have an application for review of the decision of the court to disallow our administration of the interrogatories. And that application was fixed by the court itself for hearing on the 28th of January. And therefore, we thought that given the impact of the interrogatories on our witness statement, because if Jane Mensah answers all the questions, they will bear on the nature, content, and scope of our witness statement. And therefore, we said, let us abide the decision of the court with respect to the witness, the review application, and after that, we will incorporate the answers into our witness statement. That is what that is why we brought the application for stay. Now, as Mr. Chikata pointed out in court, there was no intention whatsoever on our part to disobey the court. I am sure in all his life as a legal practitioner, Mr. Chikata has never disobeyed any court order. And this is not going to be the first time that he has done that. And I'm sure Frank Davids and his colleagues know very well that applying for stay of proceedings means that if you take any fresh step yourself, you are undermining your own application. And I'm sure if we had been given the opportunity to move our application for stay, and if we had filed any fresh process pursuant to the orders of the court, the same people would have raised objections, saying that we have taken fresh steps, we have waived our right to have the proceedings stayed. So they were involved in double speak this morning. Yes.
They don't know that strategy
or some other processes, including the fact that you wanted some additional information to be added to the review that you were asking for. Is that not a contradiction to the fact that you had filed for a stay?
We didn't file. We didn't file another for additional information. Okay. Neither did we file to amend our application for review. What we did was to add an additional legal ground. That is different.
To the yet to be heard.
To the yet to be heard review application. Okay? So that did not in any way undercut our application for stay of proceedings. I don't think so.
Counsel, the second respondent argues that having filed their response to your statement of claim, you have used the back door to file for amendments. Do they think that it is wrong?
Well, I don't know how we came through the back door in any way. We have preliminary applications pending, and we want those preliminary applications determined before we file our witness statement. We are not waiting for them to file so that we can then, come through the back door in order to be able to make our case. We knew our case beforehand, and we thought carefully about our case before coming to court. We are not relying on them in order to win this case. Yes. Now, one at a time.
You were given 24 hours, the last hearing, file your witness statement. During that particular hearing, your counsel, Mr. Chikata, raised concerns with the duration of the time given. Today, you've been given the same duration of time, which is 24 hours, by close of working day tomorrow. Do you have concerns with that particular time?
No.
Initially, you had concerns with the same duration given.
Well, you see, the initial concern that we had related to the compression of the time for case management. The fact that we came for case management and we were not given an opportunity to determine, for instance, how many witnesses we were going to call, how many documents, and the nature of the documents we were going to tender, and so on and so forth. That is what case management is about. And that is what determines the period of the trial. Okay, so if, for instance, we are calling only one witness, the court may decide that that witness should be cross-examined just for 2 days by each of the respondents. Okay, if we are calling 5 witnesses, then we are looking at a 10-day period of cross-examination. So that is why we thought that the compression of the time for case management was not, proper. And then also the fact that we're giving just 1 day in order to file our witness statement. Okay, but we are prepared, and the witness statement will be filed with all its exhibits, by close of day tomorrow.
The court made reference to
Sorry.
Rule 7 of CI 16,
That is so.
making the point that should this compare against it, reserve the right to dismiss the petition and trial. What's your assessment?
Well, I mean, we are fully aware of the consequences of Rule 79 of the Supreme Court rules. It's a rule that cuts across from district courts all the way to the Supreme Court. And as lawyers, we are very much aware that if you fail to take a step ordered by the court is within its, discretion and power to, dismiss your application or the case that you have brought. And so we are very much aware of it, but we don't intend to bring about a situation that will trigger the application of Rule 79. The witness statement will be called, filed tomorrow, and I am very sure that being a public document, the press will have copies of that witness statement.
Also, there's a rule in the Supreme Court and affirm that Stanley Commercial Court indicating that self-application does not necessarily mean that the proceedings case should be again should be put on hold. What is your response to that?
Well, I like the fact that you are attempting to be a lawyer, but the fact that came out very clearly in the last hearing. You remember one of the justices asked Mr. Chikata whether by filing his application for review, that is an automatic stay of proceedings. Okay. Now we need. That means that was a hint that we needed to bring a formal application if we wanted stay of proceedings, and that is exactly what we have done. Okay. We didn't depart from the established rules, practices, and conventions of the superior courts.
We didn't disobey.
Thank you very much. The 42-day rule. We just spoke with counsels for the petitioners. They indicate that the counting of the 42 days is based on the number of times the court sits. I've been talking about the petitioners attempting to delay the process. Now, their calculation appears to be totally different from your calculation. They also tell us, the media, that indeed the rule says from January to March. And when you calculate from January to March, it amounts to 90 days and not 42 days.
Well, it's interesting because at first they were the ones who were touting this argument that the court had set 42 days as the timeline. And we reminded them that the court had not set any 42 days. The law that was passed under the supervision of my learned senior, Maretta Briopong, when John Dramani Mahama was president, is the one that gives a 42-day timeline, not 90 days. Now, when you go to the second schedule of CI 99, and I want to encourage you, our colleagues in the media, to just find it and publish it. Filing and service is on day 1. And in practice, in accordance with CI 99, you have up to 21 days to file the petition. But the moment you file the petition, day 1 starts counting. It's not the number of days that you are sitting in the court. Because if that would be the interpretation, you cannot start counting from day 1 because the court would not have even empaneled by then. Then by the 7th day, By the 7th day, it is expected that appearance and answer would have been entered. This petition was filed on the 30th of December. Even if you said by the 1st of January or 31st, what it means is that by the 7th or getting close to the 10th, appearance and answer should have been entered. By the 10th day, it is expected that pre-trial will commence. And pre-trial, which combines a number of things, case management, memorandum of issues, orders and further orders, are expected to take about 5 days. This is how come my learned senior Dominic Ayine was talking about 5 days, 5 days, 5 days. Because CI 99 gives you pre-trial starting at 10th, and by the 15th day, hearing is supposed to be occasioned. Then by the 21st day, between the 15th and the 21st day, hearing is supposed to have ended. You can calculate the number of days yourself. And then by the 42nd day, judgment. If you do the calculation, it's somewhere around the 19th of February. If you deliberately end, it is around the middle of February, because for the presidential election petition, weekends, public holidays all count. Weekends and public holidays all count. We didn't pass this law, they did. But even if you choose to add or take out weekends and public holidays, that's how come you end in the first week in March. So anybody going around saying that it's 90 days, with the greatest of respect, is not reading the law. Now this afternoon, you have heard colleagues from the other side refuse to speak first to the issues in court, and then now raise objection with our use of the word theatrics.
Yes.
We are of the respectful view that what they are doing, as has been said by some, is 15% law, 85% propaganda. Because what they are doing is that they are refusing to follow the rules that they themselves even supervised and the orders of the court. As has been mentioned, the rules of court are quite clear. When a district court in Ofuase gives an order, not a suggestion, not a question of counsel, an order from a district court, you don't violate it that you are counsel and you think otherwise. The Supreme Court of the Republic of Ghana gave all of us orders on the 20th that we should file statements. Why? Because the court has been invoked and now is seized with issues, and the petitioner has to file his witness statements. So the court will now look at those witness statements, compare that to the witness statements of the respondents, and then we begin to proceed. The one who has to ensure that the court is seized with the witness statements refused to do his.
No, well, so the word refuse may be too strong, because we heard Mr. Chachuchikata say in court that they did not file because they had already made an application for a stay of proceedings, and based on that they did not file, not because they wanted to disrespect the court.
Every lawyer knows that when the court gives an order, it is not within your bosom to explain that I think that because of X or Y or Z, I ought not to comply with the order. Every lawyer knows that. And that is why the bench asked them that while you refuse to file those processes, you still filed other processes. Are you saying that those other processes are not connected? You want us to follow the processes you are filing, but the order of the Supreme Court of Ghana you don't want to follow. Assuming, without admitting, that this court comes to the view that there was no winner, and orders that there should be a rerun of the election, you expect the EC to follow? Or the EC and its lawyers should also explain that they are of the view that this is an order of the Supreme Court of the Republic of Ghana. And you saw them today in court. First of all, Mr. Chikata was not in court early enough. His colleague, Mr. Letha, was in court and speaking on his behalf. Then he comes in, by which time they've made those arguments that they were under the impression that their application for stay of proceedings, what is it? It's a superior application to the order of the Supreme Court. Colleagues, you are beginning to see what we have been talking about, that there are efforts to put impediments in the way of this trial. Now, finally, the court, we think, has been overly magnanimous, overly indulgent, because ordinarily the rules are clear. If you do this in the district court, they will strike out your matter. In the high court, they will strike out your matter. And today the court was appeased to read the rules one more time to learned counsel. They usually don't do that. Those of you who cover court, they usually don't do this. The court has read the rules that when you file a petition and the court gives orders that bring your witness statement, you know that even if some interlocutory matter becomes relevant, you can always come by supplementary to add it. But you are deliberately pretending that until your review or your stay is granted, you are stopped from going ahead. No problem. But the court today has been overly magnanimous in making the point that if you don't do it, the rules of court are clear, that they will strike out your petition. I mean, I think, for example, supporters of the NDC should be talking to their lawyers and their petitioner by now, because what is happening is that they have told them one thing in the public domain, that they have won this election. Then they have come to court to say they didn't win and Nanado didn't win. Now the court says, come and prove it. We are ready to prove it. And you have seen the theatrics. And we are very, very respectfully of the view that what they are doing is theatrics. 85% propaganda, 15% law. But we are in the hands of the court, and we look forward to what will be decided in the end.
All right. Thank you very much, Honorable. We are very grateful for your time. And that was the Honorable Kojo Ponkroma, who is the lead spokesperson for the first respondent, in this case, Nana Adodankwa Akufo-Addo. And we will have some other interviews. We're speaking to another counsel, one of the legal team members of the petitioner, former President John Dramani Mahama. Mr. Adawudu, thank you very much, sir. I remember we did this some 8 years ago. We're back here at the same spot, except that this time around you are on the side of the petitioners. Today you went to court, and it appears you were not prepared. You were expected by now to have filed your witness statements. Obviously, that wasn't done. The court thought that was disregarding its directives. How do you respond to that?
No, there's no way we would disobey the court order. The court was clear. As courtroom practitioners, when we go to court, we understand the rules, we understand the processes and the procedure. So if you are not a practicing courtroom lawyer, you may not understand the processes and you may interpret it in a different way. What all we said is that, yes, the court has made an order that file your witness statement. Now, we are saying that once we are to file that, we had filed for review of the decision that was made earlier. And that review that we had filed with the interrogatories will have an impact on our witness statement. Now, one of the rules is that if you have asked the court for a stay of execution, or there is a procedural irregularity, or you think there is a problem with the process, and you file for stay of proceeding, you don't go ahead and file another process, because the other side would say that you have taken a step. A step means that you have filed different processes. So you are undermining your own state of proceedings.
But were you not undermining the court itself when the court has given you a directive, and could you call a directive?
The rules also are part of the court processes. So the rules also make room that you cannot undermine, or the rule says that if you file a different process, then that means you've taken a step. And if you've taken a step, then that means what you have filed for the stay or stay of execution becomes, moot. It becomes moot. So that is why we were following the procedure, the rules, and we came. So it is either we're looking at two things. If it is dismissed, our review, that means that the questions cannot be put in our witness statement, and we will have asked for leave of the court to file the witness statement. If it was granted, we will incorporate it into the witness statement and still ask for leave to file that, because there are circumstances which the court understand, and the circumstances were legal and they were procedural. That's why we could not file. So this is it. So if you don't practice in the courtroom or with the rules, you may not understand it.
This is it.
But throughout this process, the petitioner, first of all, asked for an amendment, and then for interrogatories, then for a review. Even yesterday, there was a new application for additional points to be made for the review, and then again for the removal and replacement of paragraph 28. It does appear that from all these actions, the signal you're sending out there is that you're really not prepared, and your opponents say you are delaying the case intentionally.
It is the flip side of it. If we are not prepared, we won't have seen the rules, that the rules has provided us with a right. And it's only for us to exercise those rights. The rules are cold. They are cold letters in the books, the statutes. And those rights that is given us and the processes, that is what we are just going through. So if you see, the courts hasn't got problem with us when those are filed. It is our opponents who thinks that you file these processes. And it means that we are reading, we are researching, and we are seeing the rules that can be applied. And we are making use of all those rules. Now, you said that, yes, you don't go on protest, no demonstration. They try to gag us, stop us from going on demonstration. They say go to court. Go to court. If you have an issue, we are in court. We have fought and we said things that has been done is unconstitutional. And you see, when justice is being done, it must be manifestly seen that justice is being done. It also, the reverse is that justice hurried is justice buried. So if you go through the process without making use of the process, is the right that has been given
justice
to you.
Justice delayed is also justice denied.
Yes, so, and that is why the same Supreme Court would tell you that, yes, the judiciary should be vigilant so that there will be a balance between vigilance and a system that does not abuse the right of litigants that appear before them. So you don't say that because the rule says 42 days, and that 42 days, as explained by the lead counsel, it is the rule, CR 99. If you look at the schedule, it says from January to March. It is 42 working days when they will sit,
but
right?
Your colleagues from the other side says that it's not necessarily the 42 working days, and that weekend holidays are all part of the period.
If they are putting different interpretation on that, and we are also putting different interpretation, then it is a court that is to the intention of the lawmaker. The lawmaker has put it there in black and white, January to March. The lawmaker could have said, if you file the petition, maybe the runoff will have been on 7th January, elections are, the declaration is done. The moment you file the petition, we have 42 days.
Okay, so look, run off for elections, for example. Elections are held on the 7th December. If there is no clear winner, 21 days. How is that calculated? And based on that calculation, we'll probably be able to tell now, so the 42 days are also calculated.
So the calculation starts when you file the petition. Those processes, it has to be served. And even in CI 99, it talks about the number of days. You serve, they respond. You have pre-trial for 5 days. After 5 days, then the hearing will have to commence. Right. That was why the Supreme Court in the earlier ruling said that although they accepted the CI 47, which is the rules we use in the High Court because it is not part of the Supreme Court, they used it in 2013. But this time, because of they want expedition, they will not apply some of those rules. And that's why we're saying that these are rules.
Is that what they said?
No, they said it will not apply.
No, because new rules since 2013 have emerged.
Yes.
Concerning election petitions in particular, not because they wanted to ignore the previous ones, but because new rules have emerged.
Yes, but the fact that new rules have emerged does not mean that the rules do not still apply. Because we still use CI 47. And even when you come to Supreme Court, it is still part of it. So are you saying that because new rules has emerged, we are throwing out the old ones? No, that's what we
have filed for review and say that let's look at it. And what we are saying that, yes, and the same Supreme Court in review application says that they have taken judicial oath. If their own judgment is brought before them, they should have the courage, their conscience should be able to look at it again. And all we are asking is that the issue on interrogatories, look at it again, look at the law, and when you look at it, you can make a decision. That's all about the review. Is that your own decision? Look at it again. We are suggesting that there might be an alternative, and look at it, and let's move forward.
And my final questions, a question maybe before my other colleagues come in, will be that you have until close of day tomorrow to file your witness statements. Failure to do so, the court says it may invoke CI 16, which could also include be filed. All right. Counsel, thank you very much. We're grateful for your time. And we've been speaking to one of the legal team members of the petitioner, Mr. John Dramani Mahama, former president. And he tells us they will be able to file before close of day tomorrow to avoid a situation where CI 16 could be invoked, and that could lead to a dismissal of the petition. We'll be joined by my other colleagues, of course. Edo Nyako is already here with me. So when we were coming to court today, we were torn between a number of issues. Little did we know that what emerged today was ever going to happen. And Barbara Kuma will also join me at the moment. Barbara, you will stay to my left-hand side. What were your expectations ahead of today's sitting? I obviously was expecting that the review application would be attended to, and then again the other issues that were filed at about 2:30 yesterday would also be attended to. Obviously that didn't happen.
Yes, like you said, that was our expectation, because we knew that the court had indicated to a large extent that today we're going to see something of that sort. But you know, it's always, we are told that they are the rules of the game. The court, the justice of the court, they are in charge and determine what is relevant to them in every case. So to them, today what came up was the most important thing to be dealt with. And so they looked at it, and it's very interesting that today we're seeing that the issue of the number of days that CI 99 talks about, some say 42, some say 90 days.
Well, some say 3 months, actually, yes.
Exactly. So we're seeing things coming up as and when, and that's the beauty of the law. And that's why it's always said that it's the justice of the court, they are the one that have to interpret what the law says. So we're waiting to hear from them, and I hope that this time around, as the court has given its orders, the witness statement will be filed, as the counsel of the petitioner, one of them, that would have just said that they're going to do that. Hopefully, God gives us grace, they're going to do that quickly. And also, one other thing that I'm expecting to see, that like the court said, by Thursday, they will come back to court. So I'm hoping that the review application I talked about will be dealt with, and then we move on with the case, because what I would like to know is holding us back to some extent as a country. And if I'm an investor, I want to come and do business in Ghana, I'll be looking at this to see how it's panning out. And so these are the issues that need to be dealt with. But like they said, justice held could be buried as well, and we also quoted delayed is denied. So there must be the need to strike a balance, and that is what the law is about, so that you are not severely dealt with, but you know what you stand for. And so we're waiting for the justice of the Supreme Court to take us along as the cases.
I'll turn to you when I do so. For us to wrap up, I'd like you to try and get a peek into what might happen in court on Thursday, looking at all the outstanding issues, how they're likely to pan out. But Barbara, you sat in the courtroom yourself. For those of our viewers who are lay people who probably even didn't watch from the beginning, summarize for us what happened in court.
Okay, so today we're supposed to start the trial itself, as was ordered or scheduled by the courts the last time. But the court had actually ordered the petitioner to file his witness statements the day after the hearing, and then subsequently the other parties in the petition to file theirs the following day after that. But in court, we realized that the petitioner, that's the former President John Mahama, couldn't do as the court said. So they came to court with 2 more applications, if I should say. One for a stay of proceedings, so that their earlier application, which is for the review of the ruling of the court on the interrogatories to be heard before any other thing is done, and then another one for the amendments and additions, and they explained that's not an addition, it's that and that, but that's what they wanted to do this morning in court. But the court had its own decision. It said that, well, if you don't file the witness statements like we asked you to, they can't also consider your application. So come back tomorrow on that's Wednesday 27th, file the witness statements as we have told you or ordered you, and then we come back on Thursday and listen or hear you out. Because that's what happened in court today. Yeah.
But the judges at a point expressed dissatisfaction for want of a better word, at the petitioner's lawyers' inability to file. They said it was disregarding the rules of the courts.
Well, that's the court's opinion. They also had that reason for not filing, and I explained it to the court that they felt that
Avivia de la Signe, Betibe Magina Veno TV. Avivia de la Signe, Betibe Magina Veno TV. Agonami, Nkonye Sera Music, Mekbona Aveno TV, Hesiai.